So now we can start the event. Greetings of the day. Thank you for all joining us today. My name is Nihal Singh. I'm the event officer at Abhidhvaj Law Center. I'm very excited to welcome you all in our today's webinar, which is on topic strategies of AIBE event. So we have got a fantastic sessions lined up with wonderful strategies and insight that you will sure find valuable. Our speaker is a very experienced and have a very vast knowledge in this field. So thank you, sir, for joining us today and giving us a precious time. So before we dive in, just a couple of housekeeping note. We will be recording this session, so feel free to use the chat box to ask the question throughout the webinar. We will have a dedicated Q&A session at the end of this webinar. So, sir, so I will invite sir to please continue. So you please may continue.
Thank you for inviting me in this program, Mr. Snehil.
Thank you, sir.
So this is a question answer based program, as I have been informed regarding this webinar. So you can start through your questions. You can ask.
Okay, sir. So basically, the our first question is, sir, what is the basic exam pattern of this exam, and what syllabus we have to cover so that we can score good in this examination?
So first we need to understand the objective of this AIB exam, why this exam has been conducted. So it was started in the year 2011 for those students who passed the law degree exam in the year 2009 or 10. So from 2011 onwards, it's been continuing till now. Now, this time BCI has been conducting AIB's 19th, as I know, 19th. And the exam pattern of this AIB is that there are total 19 subjects. From the questions has been asked, 19 subjects, and 100 questions have been asked. So, how many questions will be asked from each subjects? That is predetermined. Like 10 question will be asked from constitutional law, 10 question will be asked from CRPC. Now it's called BNSS, and 10 question from evidence law. So it is predetermined. So, and exam mode is offline. There is no online exam. Exam duration for these 100 question to solve these 100 question is 3 hours, and total question, as I have already told you, 100 question will be asked. So 100 questions, 3 hours, offline exam, and 19 law subjects will be there. Questions from 19 law subjects will be there. And how many questions will be asked from each law subject, that is predetermined. For instance, from constitutional law, it is 10, Bharatiya Nyaya Sanhita and IPC 8, CRPC and BNS, BNSS, Bharatiya Nagriks Suraksha Sanhita 10 questions, CPC 10 questions, evidence law 8 questions, family law 8 questions, and law of contract 8 questions. So this is the like criteria, the questions which has been determined by the BCI to ask from these law subjects. So these are the things which every BCI AIB law aspirants should know.
Okay, sir. My second question is,
And there are
sir.
22 languages. The question
Yes, sir.
papers will be published in 22 language, that is schedule that is provided under the constitution of under the 8th schedule of our constitution. So constitutions recognize 22 language as the constitutional language. So BCI questions has been published in all constitutional language. So there is no one language question paper. So
Okay,
that
sir.
is important for
Okay,
yes.
sir. So, sir, my second question is, sir, give me some suggestion according how we can manage the time while answering the question and how much time we are supposed to give to a particular section of the exam.
Yes, first AIB exam aspirants to must know, like he or has to focus on that subjects, like in which number of questions has been asked from, for instance, constitutional law, criminal law, civil law. These are the subjects from which number of questions have been asked more in comparison to other subjects. So, and second thing, like it is a very subjective thing. If I have like interest, I my area of interest is company law, arbitration law. Obviously, my command will on all these subjects. So it depends on area of interest. So first, when you are going to appear in that exam, first you have to confine to yourself to your area of interest subjects. So first you have to solve the questions from like the questions which has been asked from your area of interest. So first you have to solve those questions. Second thing, like the questions are at very basic levels. They ask from very basics of law. That's why this AIB has been conducted. First thing is that, like I have already mentioned, the objective of this AIB exam is that they conduct this exam to assess the basic advocacy skills of a law graduate. First, this is the objective of AIB, to assess the basic advocacy of the law graduate, and second is to provide the certificate of practice. In short, called it is called COP to the uh, new lawcomer or new law aspirants, new law advocates. So these are the two objectives of AIB exam. So what I have already mentioned you, the basic advocacy skills. So question has been asked from the basic level of the law, level of the like legal basic level of the questions has been asked from the basic level of the legal subjects. So you need to only confine to the bare acts of all these 19 subjects. So question will be asked only from the bare acts. Nothing it question will not be asked from any side outside the bare acts. And they will ask very basic questions of the bare act provisions. For instance, they may ask, like there is a provision of NCDRC, National Commission Redressal National NCDRC, National Commission for Dispute Resolution, or something. So, what is the provisions under like NCDRC under the uh, Consumer Protection Act 2019? What is the provisions for the establishment of this NCDRC? What is the provision for the establishment of State Consumer Redressal Commission? So only they ask bare act provisions. So you must confine yourself to the bare act provisions. So when you appear in the exam hall, first you have to solve the questions from your area of interest. Second thing, when like there is a 40%, you need 40% marks, minimum 40% marks to qualify this exam. Well, that means 40 to 45 marks out of 100 you need to qualify this exam. So first you have to solve these 40 to 45 marks questions so that you can uh, secure your marks to qualify these exams. Thereafter you can solve other questions. So if you don't know even this, you cannot solve these 40 to 45 questions in the examination hall, then you can help to from the bare acts. So you have to also carry out the bare acts in your examination hall, so that if you are not in position to solve these 45 questions, then you can obviously can you can help from the bare acts to solve these questions.
Sir, sir, now my third question is, sir, what are the basic important subject on which we have to mainly focus, and also some important case laws which we have to keep in mind while preparing for the exam?
So as I have already mentioned earlier, that there are subjects from which number of questions have been asked in comparison to others. For instance, constitutional law, 10 questions have been asked. IPC and Bharatiya Nyaya Sanhita law, 8 questions have been asked. CRPC, evidence law, CPC, and family law. So if you will follow all these subjects, for instance, constitutional law, IPC, CRPC, CPC, family law, law of contract. So it constitutes 60% of questions of all 19 from all 19 subjects. So if you prepare all these subjects, so you may qualify this exam. There is no need to focus on other subjects. So these are the most important subjects upon which you need to focus more and more, and they will ask only basic question from these subjects. So you don't need to read other subjects apart from the bare X. So you must only focus on bare X, and it may constitutional law, it may CRPC, CPC, BNS, every subject. So you must only to focus on bare X. Second thing, what is the like important constitutional cases or other kind of landmark cases? So it varies subject from subject to subject basis. There is no fixed criteria to determine what is the landmark cases and what questions may be asked from the BCI in AIB exam. So what you have to do is that you have to only remember the only, and you have to go through only the landmark or popular cases of that particular subject. For instance, like in constitutional law, we can say like privacy judgment, KS Puttaswamy case, Shreya Singhal case, freedom of it is related to freedom of speech and expressions, narco analysis test, polygraphy test, and NDPS DNA Act. Sorry, so Karnataka versus Selvi sometime. So you need to focus on that case law, which is very popular, landmark, and very impactful case in the context of the society and the law. So 377, decriminalization of section 377. So these are the cases you need to remember, you need to focus on. So I think rather than you are focusing on case law, you must focus on bare act provision, because only 10 or 15 questions have been asked in the AIB exam from the case law sections. So even you are preparing for the case law, only you read the landmark cases of that particular case. So the case which determined some kind of principles, which laid down some kind of jurisprudence. So only you must to confine only that aspects only.
Okay, sir. Now, sir, there is a question.
So first you complete,
Okay, sir.
then we will.
Okay, sir. Okay, sir. So now, just a second. Now my fourth question is, sir, what basic strategies we should have follow while giving the mock test for preparing regarding the same exam?
So again, I will say same thing. Uh, they ask just basic question, so you don't need to worry about these exams. You don't you don't have to involve in like very depth of understanding of the subject matter. Just go through the basic questions. For instance, if you want to understand the patterns of like how what kind of questions have been asked by the BCI, then you must follow the previous year of question paper. Just if you can purchase this from market, or you can download it from the net, of last 5 year questions, last 5 year, just it, and just solve it, and you will get everything from there. So for the mock test preparation, just practice or solve the previous year questions of last 5 years, just it, or nothing else.
Okay, sir. Sir, as it is the open book examination, so sir, can you give me some tips about how we can give this open book exam, and how we can also organize our content.
That's yes. So first, I have already mentioned it that you don't need you don't need to buy any other book rather than Bear X.
Hmm.
So even you don't have carry out the, other books except the Bear X to the examination center. So when you have covered 40 questions or 45 questions, and you have the confidence you have ticked right answer of all 45 questions, then if you don't know the other answer of other questions, then you can obviously take help from the Bear X. And so if so as I have already told you, they ask questions only from the basic question. So what is, just for instance, I have told you, like they will ask like what is the minimum punishment for this offense, what is the what kind of thing constitutes like the offense, theft. So you must have knowledge about this, where is the this provisions of theft under the BNS or the IPC. So then you will be in position to mark the correct answer. Otherwise it will only consume time. If you have you if you don't have basic understanding about the subject, even though you have the bare X, you will not be in position to find out the correct answer. So if you want to find out the correct answer, just go through once the provisions of bare X in each subject, so that if you so that when you will get the copy of question paper, you will be in position to understand like where you can get this answer in a particular bare X. So before going to the examination hall and you will directly open the bare act to find out the answer of some questions, so first you need to go through all the provisions of all the bare acts before the one night of your exam. This may help you.
So,
Yes.
now, sir, as you have also attempted this examination, so what was your experience for after giving this exam, or before you were preparing for this examination? What was your overall experience?
So I got 80 something marks in that exam. I have मैंने कोई हेल्प नहीं लिया था
Yes,
बेयर
sir.
एक्ट से। और क्या है कि जब आपको पता होता है देन यू विल बी इन पोजीशन टू हेल्प अदर आल्सो, है ना, एग्जामिनेशन हॉल में। सो वही पोजीशन मेरा भी था कि पहले मैंने सारे जितने भी 19 लॉ सब्जेक्ट्स हैं, सो आई हैड गॉन थ्रू ऑल प्रोविजंस ऑफ ऑल bare acts of all 19 subjects. Then I sit in the examination hall. So ये कंप्लीट हो गया था मेरा। तो वही सेम चीज़ मैंने यहाँ पे भी बताया कि आपको यदि एग्ज़ाम हॉल में जाना है तो पहले आप ये 19 सब्जेक्ट का बेयर एक्ट का बेसिक्स प्रोविजंस को पढ़ लें। कोई नहीं, 1-1 घंटा लगता है, इससे ज़्यादा नहीं। तो आपका ये सॉल्व हो जाएगा। अदरवाइज़ बेयर एक्ट ले भी जाएँगे आप एग्ज़ामिनेशन हॉल में, तो किसी का बेयर एक्ट बहुत ही, जैसे आर्बिट्रेशन एक्ट है, वो काफ़ी मोटी बुक आती है, फिर आप कहाँ उसमें ढूँढेंगे? तो उस समय आपको प्रॉब्लम क्रिएट होगी। यदि आप पहले रात को ही उसको पढ़ लेते हैं, या एक बेसिक आइडिया होती है कि यहाँ मैंने ये चीज़ इस बुक में पढ़ा है, तो आप वहाँ पे अच्छे से उस ओपन बुक का लाभ ले पाएँगे। सो ये सुझाव है मेरा।
Okay, sir. Now you all may ask the question to sir. Sir, here is one question of Kiran ma'am. Uh,
Yes.
so which criminal bear act we should follow, new one or old one?
So as per the syllabus recommended by BCI, you must follow both old as well as new। तो ये है, क्योंकि उन्होंने लिखा है कि आईपीसी न्यू एंड भारतीय न्याय संहिता बीएनएस, सॉरी आईपीसी एंड न्यू भारतीय न्याय संहिता बीएनएस, so it includes both old one and new one, so you must follow both।
Okay. Now you all guys may ask the question.
Say though there is no limit of attempts in this exam.
Yes.
Infinite attempts you can participate in this exam. There is no limitation in terms of attempt. No negative marking is also there. In case of you marked wrong answer, there is no negative marking in this exam.
Sir, there is a question. Uh,
Yes.
so we can also bring handwritten notes or not?
Yes, as far as I know, there is no bar on written notes. तो वो चेक ही नहीं करते हैं आप बुक में क्या लेके आए, तो आप बुक के अंदर भी इसको रख सकते हो। पर कोई हेल्प नहीं करेगा। सबसे सबसे यदि कोई चीजें हेल्प करने जा रही है तो वो आपका बेयर एक्ट है। इट विल ओनली हेल्प्स यू।
So there is another question. How to read the Bear Act in a easy way? Could you please give any tips for that?
Again, it is a subjective question. It depends on person to person how can you manage these things. So वो चैप्टर वाइज होते हैं। आप बेयर एक्ट ओपन करोगे तो डेफिनेशन क्लॉज, इस्टेब्लिशमेंट क्लॉज, तो आप उस तरह से, और सभी बेयर एक्ट का लगभग सेम टाइप ऑफ फॉर्मेट होता है। फर्स्ट डेफिनेशन, फर्स्ट इंट्रोडक्शन, डेफिनेशन, इस्टेब्लिशमेंट, पावर, फंक्शन। तो जो 70% वेरेक्ट है वो आपका ऐसे ही कवर हो जाएगा। खास करके जैसे इन्वायरमेंटल लॉ है, साइबर लॉ है, लेबर एंड इंडस्ट्रियल लॉ से भी काफ़ी क्वेश्चन पूछे जाते हैं। 4 इन्होंने दिया है पर 4 से ज़्यादा ही रहते हैं। तो ये है कि ये आपको खुद से मैनेज करना होगा कि आप बेयर एक्ट को किस तरह से कितने कम समय में इफेक्टिवली रीड कर सकते हैं। क्योंकि मैं एक तरीका आपको बता दूंगा, वो तरीका मेरे लिए बेनिफिशियल है बट आपके लिए नहीं हो सकता। तो आपको उस पर काम करना होगा खुद के लिए। जब आप 2-4 बेयर एक्ट पढ़ेंगे तो आपको समझ में आ जाएगा कि किस तरह से इसको पढ़ना है। फर्स्ट यू मस्ट स्टार्ट योर रीडिंग बेयर एक्ट।
Sir, is there any limitation for bringing a Bear Act? Of sir, मतलब these are also
नहीं है, नहीं है, नहीं है। और क्या हुआ था लास्ट टाइम जब मैं अपेयर हो रहा था, तो इसमें किसी ने पूरी बैग भर के ले आया था 25, 30, 50 किताबें। और ये हाल हो गई थी कि उस बिल्डिंग में लिफ्ट नहीं था और स्टेयर्स पे खुद से चढ़ रहे थे, लेके गिर गए थे। तो ऐसा काम करने से कोई फायदा नहीं होता, ये आपको हेल्प नहीं करता है और फ्रस्ट्रेशन बढ़ा देगी एग्जामिनेशन हॉल। आपका 19 सब्जेक्ट्स का आप बस बेयर एक्ट लेके जाइए।
okay.
क्वेश्चन उससे आउटसाइड में होंगे ही नहीं, तो आपको यू मस्ट स्टिक टू द बेयर एक्ट्स ओनली।
So also there is I've read a provision regarding that we have to bring Bear Act which do not contain landmark judgment or any comments regarding
यस,
this.
ये एक रूल है। तो वो इसलिए एआईबी के लिए अलग से बेयर एक्ट पब्लिश होती है। आप कोई भी बुक स्टोर पे जाएंगे, लाओ भी बुक स्टोर पे उनको बताएंगे, वो उसी हिसाब से बेयर एक्ट को पब्लिश करते हैं। तो जो आप लैंडमार्क केस के बारे में पूछ रहे हो, ओनली 5 to 10 क्वेश्चन हैव बीन आस्क्ड फ्रॉम द लैंडमार्क केसेस। सो वो लैंडमार्क ऐसे केसेस होते हैं जो आप कहीं ना कहीं सुने होते हैं। तो आपको इसलिए मैंने बोला यू जस्ट प्रिपेयर ए चार्ट ऑफ लास्ट 5 years, है ना, कि टॉप 100, टॉप लैंडमार्क 50, 100 और 200 केसेस, और उससे वो कवर अप हो जाएंगे।
Yes, sir.
जैसे हमने आपको बताया ये नार्को एनालिसिस, और कुछ कुछ केस लॉ है जो जैसे अभी यूसीसी का चल रहा है ना, यूनिफॉर्म सिविल कोड। तो यूनिफॉर्म सिविल कोड का कौन सा लैंडमार्क केस हो सकता है जो यूनिफॉर्म सिविल कोड की बात करता है? सुप्रीम कोर्ट का श्रेया मुदगल केस है स्टार्टिंग का। तो उस तरह का केसें आप उस तरह से आप देखिए जो कंटेम्प्रेरी इशू में चल रहा है, कुछ उस तरह का लैंडमार्क केसेस, चाहे वो क्रिमिनल का हो, चाहे वो कॉन्स्टिट्यूशन का हो, चाहे वो दूसरे सब्जेक्ट्स का हो।
Does anyone have any question to ask? This is the time you may ask it. You can open the mic one by one, or you can also type it in the chat box.
जैसे कई लोगों को लगता है कि फ्रॉम लाइक ये 19 सब्जेक्ट्स है, टैक्सेशन लॉ है, कंपनी लॉ है या फिर लैंड एक्विजिशन एक्ट है। अब इसमें कोई ज़्यादा दिमाग लगाने की ज़रूरत नहीं है कि जैसे दो दो क्वेश्चन पूछे जाते हैं लोगों से, तो आपको अपने हिसाब से वेटेज भी देखना होगा कि किस सब्जेक्ट पे आपका कमांड है और उससे कितना क्वेश्चन पूछे जा रहा है।
हम्म,
तो जब आप 50 क्रॉस कर जाते हो कॉन्फिडेंट लेवल में, तो फिर आप अलग सब्जेक्ट जो एक्स्ट्रा सब्जेक्ट है उस पर फोकस। पहले जिस पे आपका कमांड है 50 to 60 मार्क्स का, आप उससे प्रिपेयर कर लीजिए।
Sir, according to you, what are the main subject? So, मतलब whose weightage is more? Which subject?
Yes, I have already mentioned these subjects. Constitutional law, first, second IPC and BNS, now new act, CRPC and BNSS, CPC, evidence law, family law, law of contract. So these are the 6 subjects which constitute 60% question of all out of 100. So you can focus on these subjects. Only the bare provisions of these subjects. Don't go into the depth or details of the subject matter.
Does anyone have any question to ask? So, also, sir, do we also have to give a personal PI, personal interview after clearing this exam to attain the certificate of practice?
No, there is no even during the like state bar council. If they don't ask any kind, they don't conduct any kind of personal interview things. Generally, they just directly provide the COP to your respective state bar council, and you can collect from there. State bar council conduct personal interview. Some state bar council, not all state bar council.
So, the question is, uh, so any limitation attempt the examination. So,
No, no, no. I have already to mention this. There is no infinite attempt you can make. There is no limitations.
If anyone have any question to ask, this is the time you may ask before the webinar ends. Sir, as we after qualifying and attending the certificate of the COP, sir, from which code do we actually have to start our practice so that we can become one day accessible lawyer advocate?
Any course before in as per the section 30 of Advocate Act 1961, you will be eligible or you will be entitled to practice before any court, whether it is district court, high court, or supreme court. So there is no bar like that. You can practice before any court. That is the benefit of COP.
Sir.
So before the getting the COP, you can only practice before the like your if you like if suppose I have registered or I have got my enrollment from the Delhi Bar Council, then I can only practice under the jurisdiction of Delhi court, under the jurisdiction of Delhi state. So it is the benefit of the COP. Once you get the COP, then you are entitled to get practice to across the country. There is no limitation or there is no bar. So this is the benefit of COP.
So there's a question without state license, can we appear in the high court of any state?
No, even if you got the license of state bar council, you cannot practice outside your state uh, uh, in absence of COP. So that is the benefit of COP.
So, as according to you, so new advocates should practice in a district or directly they should go in high court. According to you, what is your
So
opinion about this?
in the contemporary time, it is very difficult to say that you should start your practice from trial court or high court or supreme court. It depends on your choice and your capability. You can say if you start your practice from the supreme court, you can. But there must be some kind of motto or objective. Why do you want your practice from the Supreme Court? Why not from the District Court? Why not from the High Court? So your vision must be clear. Your objective must be clear. Why do you want to start your practice from a particular court? What you will achieve in future? If you have not a clear vision, if you don't have any kind of objective to start your practice from a particular code, then it will not work for you. So first you must uh, 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 clear your objective. What is your objective to start your practice in a particular code? Then again start your working on it. Otherwise, it will not work. So, as there is a traditional rule set by the advocates or by the bar, one should start practice from the district court because nobody will nobody will put question upon you if you make any mistakes in district court. But you cannot make such mistakes before the Supreme Court or before the High Court. You cannot uh, uh, you cannot understand the basic things of the litigation practice in the Supreme Court. You cannot understand the basic things of the in the Supreme Court or High Court. You can only understand all these things before the trial court, before the district court. So if one must know about the basic idea about the litigation, about the practice, about the procedure, about the trial. So you must start your practice from trial. but you must only confine to the law, jurisprudence, or the constitution. So it is not it is not any kind of mandatory thing that you must start from district court. You can start from high court or supreme court. So it totally depends on your objective or your motto. Why do you want to start your practice from a particular court?
Okay, sir. Uh, so as the new advocate is achieve the license or get the license, sir, there is a problem come in front of him that he particularly have to choose a sector, right? Civil or corporate or criminal. So, what, sir, according to what, sir, he basically should choose the sector?
Again, I will say the same thing. Like it totally depends on your area of interest. So 5 साल आपने पढ़ाई की, so you must develop your area of interest during these 5 years of course. आपने इंटर्नशिप किया, आपने मूट कोर्ट कंपटीशन किया, आपने कॉन्फ्रेंसेस किया, सेमिनार किया, वेबिनार किया। सो इस 5 years के कोर्स में, ड्यूरेशन में, आपने अपनी एरिया किस तरफ डेवलप किया, एरिया ऑफ इंटरेस्ट. So it will help you to decide whether you want to start your practice in criminal law or civil law or commercial law. तो ये आपको उसी 5 साल में डेवलप करनी होती है. आप सडनली और इनिशियल 10 years ऑफ प्रैक्टिस आप इधर से उधर, इधर से सिविल से क्रिमिनल, क्रिमिनल से कमर्शियल शिफ्ट हो सकते हैं. तो ऐसा नहीं है कि आप स्टार्टिंग से ही कोई स्पेशलाइजेशन स्टार्ट कर दीजिए कि लाइक आई मस्ट ओनली माई सेल्फ कन्फाइंड टू द क्रिमिनल लॉ प्रैक्टिस. नो, यदि सिविल का क्लाइंट आपके पास आ जाएगा तो आप डिनाई कर देंगे, मना कर देंगे, ये कहते हुए कि मुझे क्रिमिनल का प्रैक्टिस है, सिविल का नहीं है. तो आपको एक्सप्लोर करना चाहिए ईच एंड एवरी सेक्टर ऑफ लॉ एटलीस्ट फॉर 10 years. When after 10 years you can work on your specialization, but till 10 years of your initial practice you can explore in every each and every sector of law, whether it is criminal, civil, commercial, so that you can get the basic nuances or basic uh, procedural or legal provisions of every sector of law. And it will help you in when you will get specialization in, जैसे कमर्शियल लॉ में आपने स्पेशलाइजेशन लेना चाहते हो, तो कमर्शियल लॉ में टैक्सेशन का भी तो जरूरत हो जाती है, सीपीसी का भी जरूरत होगा. यदि व्हाइट कॉलर क्राइम कमर्शियल में आ रहा है तो आपको उसमें क्रिमिनल प्रोविजंस की भी जरूरत हो जाएगी. तो इसलिए 10 years तक आपके पास एक बेसिक्स आइडिया होनी चाहिए लॉ, एवरी सेक्टर लॉ का. तो 10 years तक तो मैं ये इसीलिए मैंने कहा कि 10 years तक आप ये चूज मत कीजिए कि आपको किस कोर्ट में जानी है और किस एरिया ऑफ लॉ में आप प्रैक्टिस करनी है. 10 years तक आप हाई कोर्ट जा रहे हैं, डिस्ट्रिक्ट कोर्ट जा रहे हैं, सुप्रीम कोर्ट, तो बढ़िया है, तीनों कोर्ट में जाइए, ट्राइब्यूनल में भी जाइए. 10 years तक आप हर एक सेक्टर के लॉ का प्रैक्टिस कीजिए, चाहे कंज्यूमर कोर्ट हो, टैक्सेशन हो, कमर्शियल हो, आर्बिट्रेशन हो, सो दैट कि आपके पास आप एडवोकेट हैं तो आपको एटलीस्ट हर एरिया ऑफ लॉ का बेसिक नॉलेज होना चाहिए. क्योंकि लॉ कोई यूपीएससी का अटेम्प्ट नहीं है कि आपके पास 3 साल 4 साल हैं, 2 साल हैं, उसी 4 अटेम्प्ट में आपको यूपीएससी क्लियर कर जानी है, उसके बाद आप बाद में एग्जाम देनी ही नहीं है. एक तो एज ओवर हो रहा है, दूसरा अटेम्प्ट भी ओवर हो रहा है. लॉ ऐसा है कि ये प्रैक्टिस है, आपको होल लाइफ इसी में रहना है, 390 जब तक आप जिंदगी है, लाइफ है. तो आप तुरंत जो प्रॉब्लम क्या है ना, हम तुरंत चाहते हैं कि कुछ अचीवमेंट मिल जाए इस प्रोफेशन में, तुरंत रिम्यूनरेशन उस तरह का मिलने लगे, उस तरह का हमें है ना सैलरी मिलने लगे. ऐसा नहीं है. आप अपना गोल सेट करोगे, 3 years में मुझे सिर्फ बेसिक पे वर्क करना है. 3 years से थोड़ा ऊपर जाएंगे, 5-7 years तक तो कुछ उस पे एडवांस करेंगे लर्निंग को, अपना अंडरस्टैंडिंग ऑफ लॉ को. फिर 10 years के बाद हम इंडिपेंडेंट हो जाएंगे, या 7 year के बाद इंडिपेंडेंट हो. प्रॉब्लम है, आज आज हमारे पास गूगल है, तरह तरह के डिफरेंट काइंड ऑफ सर्च इंजन्स है, तो हम लॉ और उसके इंटरप्रिटेशन को पढ़ लेते हैं तो हम समझ जाते हैं कि हमारे को उसका एक्सपर्टीज नॉलेज हो गया। ऐसा कुछ नहीं है। जैसे आप बड़े-बड़े जितने भी सीनियर एडवोकेट्स देख रहे हो, वो आज सीनियर एडवोकेट वो भी एक जनरेशन है। हमारा भी एक जनरेशन तैयार हो रहा है। तो वी मस्ट फोकस ऑन लाइक uh, we should keep in mind all these things when you are or we I am practicing. We should keep in all these things in our mind that we are a generation. 10 साल बाद 20 साल बाद हमारी इवोल्यूशन होगी हमारी प्रैक्टिस की हमारी चीज़ों की। तो आप उस हिसाब से पढ़िए। आप 2 4 साल 5 साल में इस प्रोफेशन में कुछ नहीं अचीव कर सकते। तो ये है चीज़ें, कोई शॉर्टकट है ही नहीं इसमें
Yes, sir.
और कोई ऑब्जेक्टिव टाइप क्वेश्चन पूछे नहीं जा रहे हैं कि आप एक चार्ट बना के फिर आपने आपको डे टू डे बेसिस पे आपके अंदर एक डेवलपमेंट आनी चाहिए, आपके अंदर एक मैच्योरिटी आनी चाहिए। डे टू डे बेसिस पे आप स्किल्स तैयार करो, है ना? उस हिसाब से आपकी डेप्थ अंडरस्टैंडिंग बढ़ना चाहिए किसी सब्जेक्ट मैटर को लेके। तो इस तरह से चीज़ें आती हैं सामने।
Yes, sir. Sir, as you have been a very experienced advocate, sir, do you will suggest any new advocate if he or she wishes to directly join corporate sector after he or she attend the COP? Might be some network issue. Just a second. Hello, sir.
Y- yes,
Yes, sir. You audible?
yes.
Yes, sir. So, sir, I was asking that as you are a very experienced advocate, so will you suggest any new advocate if he or she wishes to basically join the corporate sector after he or she attend the COP?
COP,
So, will you suggest any new advocate to join a corporate sector directly after he?
any
Huh.
advocate? No, no, I cannot suggest such kind of. Again, this is a very subjective thing. Like if I suggest ki you should join this or this person, and you will apply there, and for a moment he will not accept your application, then what you will do? You will get upset, very upset. So uh, this is a very like for me to give answer very tough matlab, this is a very tough questions. How can I give answer for these questions? So it is a very subjective thing. Just if you like आपको यदि क्रिमिनल एडवोकेट चाहिए या कॉर्पोरेट चाहिए या कमर्शियल जो भी, then just find out. That's why I told you many times that you need to focus on your area of interest first. So जब आप एरिया ऑफ इंटरेस्ट डेवलप करते हो तो इट इज नॉट ओनली लिमिटेड टू द एस्पेक्ट्स ऑफ लीगल लॉ और लॉ सब्जेक्ट्स और लॉ मटेरियल्स, इट आल्सो इंक्लूड्स द पर्सन्स, है ना? जो उस एरिया ऑफ आपके एरिया ऑफ इंटरेस्ट में एक्सपर्टीज हैं। एक्सपर्टीज इन द सेंस कि वो उनके पास कुछ एक्सपीरियंस है। यदि हम आईबीसी का बात करें, इंसॉल्वेंसी एंड बैंकरप्सी कोड का, यदि मुझे इंटरेस्ट है उसमें तो मैं उसकी सारी सब्जेक्ट मटेरियल जितने भी चीज़ें उसके साथ वो एडवोकेट वो टीचर वो प्रोफेसर जो इंडिया में इवन अब्रॉड में उसके ऊपर काम कर रहा है तो मेरे पास वो नॉलेज होना चाहिए। और यदि मैं यहाँ से किसी का नाम लेता हूँ दैट मीन्स आई मीन दिस विल मतलब विल बी ट्रीटेड एज आई एम इंडोर्सिंग सच ए सच पर्सन। सो आई डोंट वांट इंडोर्स such a such persons ki this is a popular name and you must consider this person if you want if you start your practice, so then you should start with this person. So it will not work for anyone.
So,
इवन यदि आपको लगता है कि जैसे हम नाम बड़े-बड़े सुनते हैं कि मनु सिंह भी हैं, जैसे अभिषेक मनु सिंघवी जी या मुकुल रोहतगी जी, देयर आर मेनी पर्सन्स, लेकिन हरीश साल्वे जी, ये नाम है, ये उस हाइट पे जा चुके हैं जहाँ से लॉ की अब नई हाइट नहीं इनके लिए बनेगी। इस लॉ फील्ड में, लीगल फील्ड में, हमारे प्रोफेशन में, लीगल प्रोफेशन में। तो लास्ट में आप अच्छा वो हाइट खत्म कर रहे हैं इस फील्ड में, आपकी हाइट शुरू हो रही है, तो उनके पास जाने से कोई फायदा नहीं होगा आपको। यदि आप चाहते हो कि एकदम एक्सपर्टीज के पास ही जाए, नहीं, आप उनके पास जाओ जहाँ से आप कुछ सीख सकते हो। उनके पास टाइम ही नहीं होता है। आप यदि उनके चेंबर या प्रोफेसर, उनके पास जो वही सीख सकते हैं जिनके पास ऑलरेडी बेसिक अंडरस्टैंडिंग क्लियर है और उनके पास भी उस सब्जेक्ट मैटर में कुछ एक्सपीरियंस आ गया है। तभी उनके पास वो जाने से, उनके पास बैठने से, उनके साथ खड़े रहने से वो कुछ चीज़ें सीख सकते हैं। अदरवाइज ये चीज़ें उनके भी काम नहीं आएंगी। यस।
So, sir, as the new educate should also have to choose the mentor for him or herself. So, what basic things he or she should keep in mind while choosing the mentor? Yes,
Mentor
sir.
from legal
Yes, sir.
profession. Then again, like if you are a, if you are interested in the like constitutional law, then you must know about like who, like the professor, the lawyer, the scholars, है ना, जिसने कॉन्स्टिट्यूशनल लॉ पे काफी काम किया है, जिसने कॉन्स्टिट्यूशनल लॉ के जूरिस्प्रूडेंस को डेवलप किया है हमारे कंट्री में, है ना, उनका क्या कंट्रीब्यूशन रहा है कॉन्स्टिट्यूशनल लॉ में। सो दीज आर द पैरामीटर्स you must consider before choosing one as a mentor. Mentor means you want to guide, है
Yes,
ना,
sir.
from that person. So how will you guide from that person if you, if he is not competent, if he or she is not competent? For this you must have knowledge about that person, like how that person is contributed to that particular domain of law. If that person has not contributed any to that particular domain of law, how can I or you can choose a particular person as a mentor?
Yes,
So first I must have knowledge, or you must have knowledge, that if I am choosing as a person as a mentor, then he must be contributing to that particular field of or particular domain of law. You must be contributing something to the society. He has a contribution in developing the jurisprudence of that particular subjects, है ना। ये सारे चीज आपको ख्याल रखना होगा,
yes, sir.
तभी आप मेंटर किसी को बना सकते हैं।
Yes, sir. Does anyone have any question to ask? This is the time you may ask it. We are ending the event. No question. So, thank you so much, sir. So you have explained all the things and cleared our doubt very wonderfully. Thank you, sir, for giving us a precious
And
time.
thank you very much for inviting me in this wonderful opportunity.
Thank you, sir.
Thank you.
Thank you, sir. So guys, as we are publishing the issue one of volume 3, and you all guys can also contribute to it. So you can also submit your articles, vlogs, and research paper with us. We will provide the details regarding that, how you can also submit the further details and further things, and you will also get the certificate of this event webinar within 7 days. Thank you guys for joining us today. Thank you guys.